Yes, Lord. What is item 13? In this case, Mr. Vikram Jupnath is the appellant. However, he has applied for leave until today. So may I read that matter may be posted tomorrow?
Okay. Item 13. On the prayer of learned counsel for the respondent number
1 and 2, Lord.
1 and 2, she apopongana, list the matter tomorrow. The learned counsel for the appellant, Shri V. Debnath, has also filed letter of absence till today.
Right.
May I please, Your Lordship. Lordship, I beg to mention, hearing item number 14, Your Lordship, 14.
14.
Yes, Lordship. I'm praying on behalf of.
Yes,
the
there is a
Synod.
mention memo also.
Yes, Lordship.
Mm.
This hearing come up after 2 weeks, Your Lordship.
Item 14, okay. List the matter after 2 weeks as prayed for on behalf of the revisionist, the
Yes, Lord.
petitioner,
Yes, Lordship.
on behalf of the petitioner slash revisionist. Learned government advocate has no objection to the prayer. Stop.
Much obliged.
Well, please, my lord. Lordship, I beg to mention hearing item 12, it can kindly be taken up on Friday. I have another fixed matter before this honorable court today and another fixed matter at court 1.
Friday,
Yes, my lord.
12, item 12. List the matter for hearing on Friday as prayed on Friday, that is give the date, 7th March, as prayed for on behalf of the petitioner.
Deeply obliged.
Void petition, item number 1 and 2.
May I please, Lordship.
Yes.
Yes, sir, it's been received.
Yes.
And Lordship, this matter is waiting for hearing. May I be, this matter will be listed after the listed part 1 matters, Lordship.
Yes, yes, come.
Yes, Lordship. So after the part 1 matters, Lordship.
Okay. List of the part one matters, call of the part one matters.
For admission, item number 3 and 4.
This is short matter, Lordship. I'm agreeing for respondent. Before my learned friend who is agreeing for the petitioner makes submission,
Yes.
I will be allowed to highlight some subsequent development
Mm.
that has been taken place during the pendency of this criminal petition.
Yes.
Also based on the FIR lodged by the present respondent,
Mm.
FIR 18 of June 23 was registered
Mm.
before the Mitsibima police station.
Mm.
Subsequently, GR 575 was also registered before the CGM Dimawal.
Mm.
After filing this criminal petition,
In the same matter.
yes, Lordship.
Mm.
After filing this criminal petition where the petitioner is challenging the FIR lodged by me, as well as the GR registered based on the FIR. Lordship, the issue involved has been amicably settled between the parties.
Mm.
Accordingly, a deed of compromise has been entered between the parties. And in view of which, I submitted an application before the OC Mitsibima Police Station,
Mm.
praying for to withdraw the FIR which I filed in view of the compromise.
Mm.
However, the OC, the police station returned my application that stating that GR case has already been registered before the court. Therefore, you approach the
Okay.
court for closing up the GR.
Mhm.
Accordingly, I sought permission from the CGM Dimapur
Mm.
to file an deliberate application for closing up the FIR
Mm.
and GR registered before the court.
Mm.
However, unfortunately, Lordship, the learned CGM
Mm.
refused to entertain my
Yes.
application and directed me to approach the body high court, High
High
Court
Court. Mm.
to delete his grievances. Therefore, I filed an additional affidavit enclosing all the subsequent development,
Mm.
including date of compromise. I also
Mm.
application for withdrawal of the FIR.
Mm.
And in the present case, Lordship,
Mm.
and think I'm also in favor of the petitioner for quashing up the FIR and GR, Lordship. So in the interest of both the parties, this may
Where's
be.
where's your additional affidavit?
I file on
Additional affidavit
20
on
to
behalf of respondent two, no?
respondent number 2. Lordship, I'm referring to paragraph 3, 4, and 5, 3 paragraphs, Lordship.
Otherwise, the offenses are compoundable.
Yes,
offenses.
Lordship. Paragraph 3, 4, and 5.
Mm, mm, the economy looks to state the said vehicle is just, Okay, where have you stated about the IPC section? 570, no, it's 379.
Yes, Lordship.
FIR is
It's compounded.
page number 19. The main petition.
19 to your petition.
Yes, sir. The one. Only one section is affected. 379. 1990.
That also goes in my additional affidavit, Lordship. Instead of referring to the criminal petition.
Yeah, in your additional affidavit, page.
Page 6.
Page 6. Section 379.
This is item 3 and 4, no? Analogous.
Yes.
Okay, item 3 and 4, okay.
Compromise deed is at page 10 of my affidavit.
Page. Where is the FIR filed earlier against which the petitioner has come? This is the,
This is the FIR.
Page 9.
no.
Page 9 is the FIR lodged by the
no, yes.
type copy is at page 8. Page 8
Page number 8.
is the type copy. And page 11 is the application brief for withdrawal of the FIR.
Mm.
Therefore, my humble submission is I have no objection to the
Yes,
break up to
we'll dispose it of.
petitioner for quashing of the FIR and the GR case 575.
Okay. This is an application under section 482 of the CRPC for quashing of FIR dated 2/9/2023, which is an extra one of the petition. Stop. The submission of the petitioner is that on 30/5/2023, an FIR was lodged by one Khotso, KHOTSO, Ruhia, RURHIA, before the OC, Mitsibima PS, stating that on 30/5/2023, at around 3 AM to 4 AM, his goods carrier vehicle bearing registration number NL07-AA-0123 was stolen by miscreants from the house of his driver. The same was registered on 2/9/2023, being Mitsibima PS case number 18/2023 under bracket GR 575/2023 under section 379 IPC. Stop. The contention of the petitioner is that he had purchased the said vehicle for commercial purpose, and he is the real owner of the said stolen vehicle. And accordingly, in the registration card of the vehicle, the name of the petitioner is shown. The petitioner had engaged the informant, who's the informant?
Respondent number two.
Respondent number two.
Oh,
Respondent number two.
okay, okay. The petitioner had engaged the informant slash respondent number two to run the vehicle on contract basis and there was an oral agreement between the parties to the effect that the informant would use the vehicle and pay a fixed amount of rupees 1,40,000 monthly to the petitioner. So it is also stated that the informant slash respondent number two stopped paying the amount of rupees 1,40,000 from the month of January 2023. Stop. Because of that, you took back the vehicle, isn't it?
Yes,
Because of the aforementioned reason, the petitioner took back the possession of his vehicle from the informant slash R2. Stop. However, it is contended that the FIR, the aforementioned FIR has been filed by the respondent number two. Where is your name mentioned in the FIR? The petitioner's name.
I'm not named accused in the FIR as such,
Hmm.
but since I am the owner of
Page
the
21
vehicle,
is the FIR, Lordship. I've still thought the vehicle has been purchased from
Just one
the
vehicle
petitioner.
includes carriers that inside.
Console Park.
The said vehicle was stolen by miscreants. No, but if the FIR is not lodged against you, then why are you aggrieved?
we apprehended that the police will arrest us.
Mm.
Therefore, we came before this honorable court and took the bail.
Hmm.
Thereafter, we didn't appear
So-
due to some consequences. The bail was rejected, and then thereafter also we prayed, and then we got the interim order from this court.
Where
Thereafter,
is that?
police
Where is
have been.
that stated? Where is that?
I filed my IA.
No, no, regarding that, coming before this court and obtaining the bail and all that in your application.
Yes, just give me a second.
Para 10, I think. Para 9, 10.
Yes,
Hmm,
paragraph 9 and 10.
yes. Last time, what was the last time? Yes, respondent number 2, regarding the loss of the vehicle. And the petitioner herein apprehending arrest in the said GR case had approached this court by filing a pre-arrest bail application, which was granted by the order dated 17/10/2023. Stop. And the bail was allowed with the condition that the petitioner would appear before the IO within a period of 10 days. Stop. However, he could not appear before the IO concerned, as he was being threatened by the informant slash respondent to. While matters were pending, thus, the respondent number 2 slash informant had also filed an FIR in which PS? In the Mitsipima PS, which was registered as GR 575 of 23. 575 of 2023. Dated, what is this, your FIR date? 2/9, dated 2/9/2023. Stop. Thereafter, the petitioner and the respondent number 2 entered into an amicable settlement of the issue regarding the loss of the vehicle on 3/1/2025.
32.
3/2, here you've written 3/1. On 3/2/2025, which is at annexure C.
Next appeal. Next appeal of the additional appeal,
Wait.
page number 10. Which is at annexure B. Annexure B of the additional affidavit filed by the respondent number 2. So, therefore, in view of the same, the respondent number 2 submitted an application to the OC of Mitsipima PS, praying for withdrawal of the FIR and to close the case. However, the said application was returned by the OC, Mitsipima PS, stating that the case is already forwarded to the CGM Dimapur. Stop. Thereafter, the respondent number 2 appeared before the CGM Dimapur praying for filing an IA for closing of GR number 575/2023 and withdrawal of the FIR lodged before the Mitsipima PS. Stop. However, the CGM Dimapur did not allow the said application.
stating that the court has no jurisdiction. Is there any order to this effect?
No.
Or that was just verbal? Stating that the court has no jurisdiction. Stop. Accordingly, the respondent number 2 has filed the present additional affidavit stating that he has no objection if the prayer of the petitioner in the present criminal petition is allowed. Stop. I have submitted, I have considered the submissions of the learned counsels. Shri, your name? El Singdam for the petitioner and Wati Jamil for the respondent number 2 and learned government advocate, learned PP appearing for the state respondents. So, on perusal of the records and upon considering the submissions of the parties, this court is of the view that the offense in both the FIRs lodged by the petitioner, lodged by
By the informant.
the informant number 2 is under section 379 IPC, which is a compoundable offense. Stop. Moreover, the parties have already entered into an amicable settlement, which is annexed as that earlier, that compromise, and it should see in the additional affidavit of the RT. So, in view of the above circumstances, the FIR dated 2/9/2023 and the GR 575 of 2023 of Mitsipima PS case number 18 of 2023. Is that right? The numbers?
Yes.
18 of 2023 are quashed and set aside. The LCR, any LCR here?
No.
It's okay. Quashed and set aside. The petition number 17 of 2024 and 45 of 2024 hereby disposed.
In view of the order passed on 17/2024, criminal petition was filed by the state of Nagaland.
State also.
No, cancellation of bail.
Oh.
Regarding item number 4. Item number. So that may also be closed.
Okay, so that one is item 17, okay, it's
item-
criminal, I mean 17 of 2024. Then in
45.
45 of 2024, the separate order. In view of the order passed in criminal petition 17 of 2024, the criminal petition 45 of 2024 also stands closed. The separate orders, okay?
For admission from the supplementary cost list, item number 18.
Please, Your Honor. Actually, Your Honor, there's been some confusion in the supplementary cost list,
Ah.
mostly in both the courts 1 and 3. So in the normal cost list, I check whether this present case is listed today or not.
Mm.
But in the morning only I happened to know that this case is listed today.
Mm.
And then moreover, I didn't bring the file, so my apology for that.
I think this one came up yesterday,
I
if not
think,
mistaken. And then it was passed over.
so,
We passed the order to.
yes, Your Honor.
Pass it over.
And then in the normal cost list, it was not listed, so I thought
Mm.
I overlooked the cost list, and then this morning only I came to know that the case has been listed. So my humble prayer is that it may become up on Thursday or maybe Friday.
Okay, we put it on Thursday. Thursday will be 6 now. Item 18 supplementary. The net counsel for the petitioner, Shri S. Wali, submits that he has seen the listing of this petition in the supplementary list only this morning,
Your Honor.
and therefore the brief is not with him. And he prays that the matter may be listed on Thursday. Stop. Learned Government advocate, learned PP. This is civil or criminal?
Civil revision.
Learned government pleader has no objection to the prayer. Stop. List the matter on 6th March for admission.
Your Honor, there's an interim, Your Honor.
Yes.
There's an interim.
The interim order passed earlier shall continue
Obliged.
till the next date.
Obliged, Your Honor.
For orders, item number 5.
Your Honor, notice upon respondent 3, respondent 1 and 3 is still awaited the case, so I may be granted
What
another time.
about this impleachment? Some impleachment is also there. On the prayer of learned counsel appearing, learned counsel for petitioner prays for and is granted 2 weeks time to file appropriate application for impleachment.
Yes, Your Honor. So for that, I may be allowed to file another 2 weeks time may be granted.
Heard learned counsel, Mr. S. Wali appearing for the petitioner, who prays for another 2 weeks time to file the IA for impleachment. Prayer is allowed. List the matter after 2 weeks.
Obliged, Your Honor.
Obliged.
For orders, item number 6.
Please, my lord. My lord, I'm appealing for respondent number 2. I filed my affidavit yesterday, your lord.
I think petitioner was supposed to implead the VC by name or something like that.
Lord,
Yes, Lordship. Yes, because VC cannot be impleaded in his official capacity. No?
Yes, Lordship.
Mm.
Back then, there was no VC, there was no VC being appointed at that time. And the registrar was executing the duties of the VC.
Mm.
So we have implemented the VC, but recently we came to know that the VC has been appointed.
But in any case, I think they have already complied.
Lordship,
You have complied, isn't it?
lordship, we have complied, your lordship.
Have you received the affidavit in
Yes,
opposition?
I've received it.
Yes.
This,
Do you
but
still need to pursue?
yes, I'll need to seek instruction.
Otherwise,
yes.
I've gone through the affidavit in opposition, you have been paid everything.
Yes,
Okay.
but
Maybe,
for that, yes, I'll have to seek instruction from the clients. So
when next week.
Lordship, 2 weeks. There is 5 of them.
Let's
5
try
petitioners are
next
there.
week, and by then, if you don't get the instruction, then we'll join again. Yeah. It's just in Dimapur, no?
Yes, Lordship.
Heard learned counsel for the petitioner, who has prayed for some more time to implead the vice chancellor of the Global Open University Nagaland by name. So, it is submitted that at the time when the petition was filed, the university did not have a vice chancellor, but subsequently the appointment has been made. And hence she prays for 2 weeks' time to implete the vice chancellor in his personal capacity. So, the respondent number 2, no? Respondent number 2 has already filed the affidavit in opposition. And it appears that the direction of this court has been complied with. So the petitioner is directed to seek instructions on this matter. List the matter after a week. The petitioner to get instructions. Same order in 6, 7,
Lordship,
8,
9 and 10.
9, 10. 10.
Life.
For hearing, item number 11.
May I please, your lordship. Lordship, on 13 to 2025, lordship, this honorable court has given the direction to produce the LCR. LCR. Well, we are not sure whether the LCR has been received, lordship.
I think LCR has come. DB's court.
Lordship. Yes. So, lordship, if this matter can be fixed tomorrow, lordship, because my senior he has some prior engagement, he has to like go to the lower court. So if it can be passed over for the deal.
Lordship, tomorrow I have a big engagement, so
Actually,
I won't be
what-
able-
okay, here it says, receive such and such records from Office of Deputy Commissioner Kohima. And perusal of the same, it is found that the contents at page 1, 2, 3, 4, 6, and 7 are in local dialect. So I think we will have to get translated copies also in this.
Lordship will try to lodge.
The Bashi's court record also has come, no? Miss case 6 of 18. The Bashi's court Kohima. I think it's safe. Yes. We have sent copies. But everything is in Angami dialect.
Lordship, in that case, if the copies can be furnished to us, a photocopy, so that we can translate it into the.
Learned counsel,
Mika Chayala.
Mika submitting on behalf of her senior, Mr. Joshua Sheki, has submitted that her senior has difficulties today and hence prays for when.
Lordship, if we are to translate those copies, some 2 weeks, maybe given.
Prays for some, just say prays for some time. Stop. It is seen that the records of the Bashi's court Kohima and also the records of the Deputy Commissioner Kohima are in local dialect. No, just say most of the records of the Bashi's court Kohima and the Deputy Commissioners Kohima are in local dialect, and therefore scanned copies of the records may be supplied to the petitioners so that translated copies may be made of the same. Accordingly, list the matter of the two weeks. Thank you.
Much
Learned
obliged.
councils appearing.
For respondent number one, Lord.
Mr. Siti Jamir, senior advocate, appears for respondent number one. And additional AG Sucre appears for respondent number two.
Much obliged.
For hearing, item number 15 and 16.
May I please your lordship? May I please your lordship?
Petition. Amended petition filed. Amended petition. filed. Yes. You're ready?
No, your lordship, I guess the respondent will be making submission.
May I please your lordship?
In 15.
Lordship.
15 and 16, lordship. Lordship. Lordship, the principal counsel is there here because of some medical emergency. He could not be here. Lordship.
Counsel for the
The
petition.
principal counsel for the respondent in this.
Respondent number one.
Respondent number one.
Lordship.
So you need time.
And since the counsel for the petitioner is from out of state, so he has taken the consent. So the fixed date is it is a prayer to this court, honorable court, to fix it on 18th.
18th of March.
Yes, lordship.
You are appearing for
Petitioner.
petitioner. Okay. So you are led by this H. Raman in this case.
My lord.
Okay. So would that be convenient for him? 18th,
My lord, my lord.
18th March. And what happened to your senior?
The mother-in-law is in ICU. So because of that, he's not in station.
Heard learned counsel for the respondent, who states that his senior, Mr. N.K. Luikam, has
Okay.
personal difficulties today. Stop. Learned senior counsel for the petitioner, Shri H. Raman, is also not present today as he's from Gauhati.
Gauhati.
As he is from Gauhati. On the prayer of the parties, list the matter on 18th March 2024 for hearing, 2025 for hearing.
Obliged.
Deeply obliged, Your Honor.
For admission, item number 1 and 2.
There are two criminal petitions listed in item 1 and 2, lordship. Lordship, item 2 may be taken up first, lordship. Any other bus in this criminal petition 57 will have bearing
This criminal petition 57.
will have bearing in item number 1, lordship.
Criminal petition 57.
Is Abby's lordship. Before I take your lordship petition to the imbued orders passed by the learned court below. Lordship, I may be allowed to brief lordship short facts leading to filing up the criminal case before the learned court below, lordship, how it was filed. Lordship, the present petitioner is a businessman by profession, doing supply of medicines, drugs all over Nagaland. In the year 2004, the respondent herein approached the present petitioner to run the business by way of partnership. So accordingly, in the year 2004, Lordship, a partnership agreement was entered between the petitioner and the respondents, with specific terms and conditions to be applied during the course of the business, Lordship. What happened? The respondents herein in the early part of 2000,
All parties are present.
yes,
Okay.
and due to violation of the terms and condition of the partnership, did gifted the shares of the partner, Lordship, to a third party without the consent of the present petitioner,
The respondent.
the respondent. Gifted the share of the partner's, Lordship, without the consent of the petitioner, which is in violation of the partnership deed.
Yes.
Therefore, in the year 2017, the present petitioner filed a complaint before the Chief Judicial Magistrate Timabo against the respondent for cheating and criminal breach of trust. Lordship, and accordingly, process was issued to the respondent's, Lordship. However, since the respondent herein are the residents outside the jurisdiction of the Chief Judicial Magistrate Timabo, Lordship, the process issued by the board was challenged before the Honorable Court by the respondent herein as petitioner on the ground that without following section 202 of the CRPC, process cannot be issued. Therefore, this Honorable Court remanded back the criminal petition case to the lower court below, Lordship, to issue process in accordance with section 202 of the CRPC. Lordship, when the criminal petition, that criminal petition was pending, in the proceeding of that criminal case, criminal petition, which was disposed of by the Honorable Court, the present respondent, who was the petitioner, Lordship, includes a document allegedly signed by the present petitioner, whereby it is stated that the present petitioner have consented to give the shares to the third party. That was an affidavit allegedly signed by the petitioner. Therefore, on discovery of that affidavit, that is affidavit is 15/6/2015. 6/2015. On discovery of that affidavit, Lordship,
That you had also agreed to the gifting of the
Yes.
share.
on discovery of that affidavit, Lordship, the present petitioner can file a criminal complaint for forgery of my signature in that affidavit. And the criminal case is registered as CR 12 of 22.
Mm.
And the present criminal petition number 57 of 24 is arising out of that CR
That
12 of
CR,
2022. 2024. Lordship,
Is 7 of 2024.
Mikhail
So
Khan,
CR 12 of 22 was filed by you against that forgery.
yes.
Hmm.
My complaint is at page 21 of my petition.
Annexure B.
Annexure B. This is 4-page complaint, Lordship.
Charita Das, okay,
My complaint is 4 pages, Lordship. May I read?
yes.
Because all the facts are stated here
Mm,
in my complaint.
yes.
I'm reading from page 22. Most respectfully, Lordship. The complainant is a business woman by profession and is residing within jurisdiction of this court, who is represented by her attorney holder, that is Shri Gopal Paul, in his instant case. And the accused persons are also business women by profession and were the business partners of the complainant and the firm MS so. Partnership dated 7/7/2004, and husband of the complainant, that is Shri Gopal Paul, was the manager of the aforesaid firm. 2. That to the utter surprise of your humble complainant, suddenly in the year 2015, when the partnership business was in full swing, the accused person illegally, by violating terms and conditions of the above stated partnership deed, gifted their shares part in favor of one Shri Hutui Ahomi without any information and consultation with the complainant partner, for which purpose the complainant served a legal notice upon accused persons, and thereafter complainant, after having no other option left, filed a CR case number 26 up to the 17th through her attorney holder, in which the accused person appeared after receiving summons at the honorable courts, and the instant matter was falsely withdrawn with the intermission of the accused person in collusion with some vested interest person, and on the basis of the withdrawal submission, the said CR case number 26 of 17 was disposed of by this court on 8/6/2018 without hearing the complainant in person, as on a very fixed day, the complainant was neither present in person nor any written withdrawal petition was made to that effect by the complainant. Number 3, that the complainant, after having knowledge of the said withdrawal disposed order dated 8/6/2018, referred a criminal appeal through her attorney holder, to the Shri Gopal Paul, before Honorable High Court, Gauhati High Court, Kohima bench, which was registered as so 18th, in which, after receiving the summon notice of the said honorable court, the accused person submitted a written objection by so and the said appeal. And along with the said written objection, the accused person has also submitted an affidavit dated 15/6/2015. This is the forgery documents as annexure 3 allegedly sworn by the complainant, whereas such affidavit was never sworn or signed by your humble complainant at any point of time. 4. That the complainant hereby submits that the said affidavit dated 15/6/2015 and authenticated through notary public was filed by the accused person along with your written objection by forging the signature of the complainant with your ill motive and intention to escape from the liabilities of the criminal offense, and also for trying to equate from the said case by submitting the so-called forged signature affidavit dated 15/6/2015. That it is submitted by the complainant that she came to know regarding the forged signature documents while the complainant has gone through the case record, as well as an objection by so filed by the accused person in the said appeal. And thereafter, on account of lockdown due to pandemic COVID-19, the complainant could not be able to attend the Honorable Gauhati High Court, Kohima bench, to obtain the certified copy of the same. 6. that the complainant on 10/12/2020 obtained a certified copy of the said false forged affidavit from the record of the said so and criminal appeal number so and found that the said affidavit is false, forged, as there was no such affidavit sworn by the complainant at any point of time. And the contents of the said forged false affidavit is totally false, fabricated and baseless with the forged signature of the complainant, and there is serious discrepancies with genuine signature of the complainant shown in the said affidavit dated 5/6/2015. 7. That after obtaining the above mentioned said forged affidavit dated 15/6/2015, only on 10/12/2020, the complainant approached this honorable court in the month of January 21 to file this instant case for retrieval of her legal rights and to punish the accused person for the wrongful act. But the complainant was then asked by this honorable court to wait as the main CR case report filed bearing CR case number 26/2017 is in the Honorable Gauhati High Court Kohima bench for above said bill filed by the complainant. As such, the complainant has waited for the same and only on 22/2/22, the said High Court has passed its order with direction to the parties to appear on 2/3/2022 in CR case number 26/17, and thereafter the case record has been received by this honorable court. 8. That after receiving the certified copy of the false forged affidavit dated 15/6/2015, the complainant has firmly realized that the said affidavit is wholly fabricated and graded documents which has been graded by the accused person with your command criminal intimation, motive, intention to cheat your humble complainant. As such, the accused persons are liable and to be punished for the offense of obtaining forgery for the purpose of obtaining criminal command intimation and forgery. Number 9, that the cause of action, those are not relevant. So this criminal complaint 12/22 was filed for cheating and forgery because I never signed in that affidavit which was produced by the petitioner and the criminal petition which was pending in this honorable court. After filing this criminal petition, CR case number 12 of the district, Lordship may kindly come to page 35. This is the order dated 22/3/2024. The honorable court below have taken cognizance on 22/3/2024. Merit Lordship. Dated 22/3/2024, Mr. Gopal appears on behalf of the complainant, Mambi Paul. The counsel for the complainant, B. Chen, is present. So. I have carefully perused the report submitted by the EO. The inquiry officer in para 6 of his report stated that, as per the witnesses on June 2015, an affidavit was framed by Shrimati Mambi Paul, wherein it is stated that after having due consultation with the co-partners Shrimati Charita Das and Shrimati Suizu Dipnath, both have handed gestures to Shri Hote Ahomi. Further, as per the witnesses, the said documents was personally produced by Shrimati Mambi Paul to be notarized and registered. Further, in para 7, the inquiry officer stated that Shri Hote Ahomi and Shrimati Mambi Paul in 2015 had agreed upon to become partners of MS distributors, where Shri Hote Ahomi, 2/3 partners and 1/3 partners belong to Shrimati Mambi Paul. On going through the report, it appears that IU has come to finding on examination of witness. On perusing CR 12/22, it appears that the complainant has filed a case against the accused person, namely so and so, on the allegation that she has no signed the affidavit dated 15/6/2015 and her signature has been forged. Therefore, it is said that the only dispute in regard to the instant case is the affidavit dated 15/6/2015, when complainant has totally denied the signature and the said affidavit was signed by her. Hence, this court in the interest of justice and order to provide a fair opportunity to a complainant to prove his case, this case shall proceed for further proceeding accordingly, and we observe so police has taken. The allegation NCR 12 of Duty 2 is forgery, forging my signature. Under section 200 of CRPC, my statement was taken by the court. When the meter was fixed on 31/5/2024, Lordship, the learned court below dismissed my CR case number 12 of 22 and discharge the accused person under section 245 of CRPC. Lordship,
Let's see the order.
the simple issue in this present petition is without using evidence under section 244 of CRPC, prosecution witness, the court below cannot dismiss my petition and cannot discharge the accused person under section 245. That is the core issue in this petition. Because no prosecution witness evidence was accused under section 244 CRPC on 31/5/2024. Therefore, how the London court below bars an order under section 245 without accusing evidence under section 244? Lordship, may kindly come to page 41. Page 41 of my petition. This is also 4-page order, Lordship.
CRPC.
The issue involved here is section 244 and section 245 of CRPC only, Lordship. The interpretation of section 244 and 245. Because under section 244, no prosecution witness was examined, no prosecution evidence was taken, and therefore the London court below cannot pass an order under section 245. Lordship may find out from the LCR whether evidence was accused under section 244.
First, let us see the impugned.
Yes, section 41. Lordship, sorry, page 41.
Mr. G.
Yes. This is order dated 31/5/24. Married, Lordship.
Yes.
Complaint, it is submitted. Lordship, I'll start from, it is submitted by the counsel for the complainant that complainant had an accused persons for business partners of a firm, namely MS so-and-so, by partnership date 7/7/24, and in 2015, when the partner's business was in full swing, accused person illegally violated terms and conditions of the partners and partnership deeds in favor of one Gateway Ahomi without any information and consultation with the complainant, out of which here case 6/17 was filed by the attorney holder Gopal Bol, wife of the complainant Magbi Paul. In the process, the said case was withdrawn without the knowledge of the complainant by the accused person. Thereafter, the complainant through her attorney holder preferred a criminal appeal at Honorable Gauhati High Court, Kohima bench, registered as CR appeal number 2 of 2018, in which, after receiving the summon notice, the accused person submitted a written objection registered as IA criminal at D of 2018, along with the said written objection, the accused person annexed an affidavit dated 15/6/2015 as annexure 3 allegedly sworn by the complainant, and it is submission of the complainant that such affidavit was never sworn or signed by the complainant at any point of time. The complainant submits that the said affidavit dated 15/6/15 authenticated through the notary public was filed by the accused person along with the so by forging the signature of the complainant with the ill motive and intention to escape from the criminal liabilities. This only when the complainant has gone through the CR as well as the so filed by the accused person, she came to know of the said documents. On 10/12/2020, the complainant obtained the CTC of the said records and found out that the affidavit is false, and there was no such affidavit sworn by the complainant at any point of time. And affidavit is totally fabricated with the complainant's forged signature. Then the counsel for the complainant also submits that after obtaining the first affidavit on 12/10/2020, the complainant approached this court in January 21 to file the instant case, but he was asked to wait as the main case CR 26/17 was pending in the Honorable Gauhati High Court, Kohima bench, and after the final order was passed on 22/2022 for both parties to appear on 2/3/22 before this court, the CR is received by this court. The complainant further submits that the accused person has forged her signature and filed the same in order to support their case. As such, they have committed an offense under Section 22 IBC. Therefore, bears that the accused person may be punished under the said section. On the other hand, the counsel for accused person submits that nowhere in the petition there is an iota of evidence for FAC to show that the accused person has committed any offense. The counsel submits that the allegation of the complainant against the accused is that they have forged the signature of the complainant and affidavit dated 15/6/15. However, none of the signatories has met an accused in the instant case. Learned counsel further submits that as per the inquiry report of the inquiry officer, there is no material to show that the accused person has committed any offense subjecting a forgery. The learned counsel has also relied on paragraph 6 of inquiry report to show that the said affidavit dated 15/6/2015 was personally produced by Shrimati Mambi Paul herself. It is also submitted that in 2015, the complainant, along with the accused person and the Nagaland Medical Dealer Association, has also settled the matter about the dispute arising between the accused and the complainant, and it is submitted when the matter has already been resolved on 2/6/2015. There is no reason for accused person to prepare the affidavit dated 15/6/15 by forging the signature of the complainant. The counsel submits that the nature of the case in regard to the date of partnership is purely civil in nature and relied on judgment of the Honorable Supreme Court in the case of so-and-so. Learned counsel submits that there is no ingredients under section so-and-so, and also added that the accused persons has never used any forged documents for the purpose of cheating, and nowhere in the petition the complainant alleged that the accused person has committed cheating. Learned counsel also submits that if there is any deed meted out to the complainant, they could have filed an FIR to the police, and instead of doing so, complainant has filed this application. Learned counsel therefore braced that there is no sufficient materials and no mens rea of the accused person is found, the criminal complaint may be dismissed. I have considered the submission of the learned counsels. Bureaus the CR having heard both counsels, it is sent that the issue in the present criminal complaint petition in regard to affidavit dated 15/6/15 said to be forged as a signature of the complainant has allegedly been forged by the accused person. The complainant Mami Bol, who is said to be one of the co-partner with the accused person, Shrimati so-and-so and so-and-so, has consented to the second co-partner accused person for handing over the shares and boundaries and partnership business MS so-and-so, do Hitui Ahomi. And further, as for the affidavit, the complainant shall diligently work with Shri Hitui Ahomi as co-partner, and the complainant shall be entitled for 100 shares in the partnership deed, that is 7704. As the learned counsel for the accused person has time and he can rely on the documents dated 2/6/2015 Annexure B and the inquiry report of the EO. I have perused the documents carefully. As per the documents, a resolution of understanding was signed by the executive body of the Suisu in presence of the husband of the complainant Gopal Paul and the husband of the accused number 2 along with others. As per the Suisu understanding, the second partners of MS Modern Drugs Distributor, namely Shrimati Jarida Das and Suisu, had gifted their shares to Hetwe Ahomi, and henceforth, 2/3 partnership will go to Hetwe Ahomi and 1/3 belong to Shrimati Suisu. As per this documents, it is said that the person, namely Hetwe Ahomi, has taken over shares from Shrimati Jarida Das and Suisu, and the said person, Hetwe Ahomi, is sent to whole Suisu partners of business. After going through the affidavit dated 15/6/2015, it appears that the affidavit is for the same reason as reflected in respect of so understanding dated 2/6/15. Therefore, it appears that when the issue has already been settled on 2/6/2015, there is no further requirement of the affidavit dated 15/6/2015 to prove that Shri Hetwe Ahomi has become a shareholder. So. Further, it is confirmed by EU in its report dated 21/3/24, para 6, that the complainant Mambe Ball, having due consultation with her co-partners, have handed over their shares to so. Hence, there is no room at this stage to doubt that Shri Hetwe Ahomi has some shares in the business. As such, it is highly thoughtful that the affidavit dated it is highly thoughtful that the affidavit dated 15/6/15 is prepared by the accused person by forging the signature of the complaint. That is all the facts, Lordship, which is not necessary at all to decide the criminal complaint. Next, Lordship. Having considered the submission of the learned counsel along with the evidence, this is very important, of the prosecution under Section 244 CRPC, which may kindly be used the records whether evidence was issued under 244. Statement of the attorney holder of the complainant and Mr. Suinso PW2, and having arrived at a finding made above, it appears that the charge against the accused person is found to be groundless. Accordingly, CR complaint 12 of 22 is hereby dismissed, and the accused person shall be discharged under Section 245. No prosecution evidence was issued under Section 244.
So what is this? The magistrate has stated the statement.
This
of
is the
attorney
statement.
holder and such and such.
This is the statement taken under Section 200.
Acha, acha.
And the statement
The
taken under
initial
yes,
statement.
statement under Section 200 cannot be taken as a prosecution evidence under Section 244. That is the law laid down by the Apex Court and as per the Section 244 CRPC. It is clearly provided that it is very clear that prosecution witness and evidence. Therefore, the only issue in this criminal petition is whether prosecution evidence was issued under Section 244. I'm saying no. Because I'm the complainant. My evidence was not taken under Section 244 on 31/5/2024. Mandatory provision has been bypassed by the learned court below while deciding the case under Section 244. Petition-
Stage of CC only it was disposed.
Yes, but
discharged.
it is clearly mentioned in the ambient order that evidence under section 244 is taken, Lordship. In the ambient order itself. So if there is any prosecution witnesses and evidence it used, Lordship, that would be followed by the cross-examination. And
Any
the-
citations?
Yes. My complaint itself is a forgery, Lordship. No handwriting expert was ordered. No forensic examination. And the alleged documents was registered before a notary public. Notary public was not summoned to authenticate whether this documents was registered, really registered before the notary public. I have two citation, Lordship. First, I'm referring to 2009, 14 ECC. I'm relying on this loss of judgment, Lordship, which I have found. Yes, so the Honorable Apex Court has deal with section 244 and 245. I am referring to few paragraphs, paragraph 14. Page 7. May I read, Lordship?
Yes.
However, and a warrant trial is treated otherwise other than police report. When the accused appears or is brought before the magistrate under section 244 CRBC, the magistrate has to hear the prosecution and take all such evidence as may be produced in support of the prosecution. And this, the magistrate may issue summons to the witnesses also under section 244 clause 2 CRBC. On obligation by the prosecution, all this evidence is evidence before the charge. It is after all this evidence is taken, then magistrate has to consider it under section 245, Lordship. It's exactly the same case, Lordship. CRBC. Whether any case against the accused is made out, which if unrebuted would warrant his conviction, and if magistrate come to the conclusion that there is no such case made out against the accused, the magistrate proceed to discharge him. On the other hand, if he is satisfied about the prima facie case against the accused, the magistrate would frame a charge under section 246 CRBC. The complainant then gets second opportunity to let evidence in support of the charge, unlike a warrant trial on police report, where there is only one opportunity. And the warrant trial is treated otherwise than the police report. The complainant gets the opportunity to let evidence, firstly before the charge is framed, and secondly after charge. Of course, under section 245 clause 2, magistrate can discharge the accused at any previous stage of the case if he finds the charge to be groundless. 15. Essentially, the applicable section are section 244 and section 245 CRPC. Since this is a warrant trial, treated otherwise than a police report, there had to be an opportunity for prosecution to lead evidence under section 244 clause 1 CRPC or to summon its witness under section 244 CRPC. This did not happen, and instead the accused proceeded to file an application under section 245 CRPC on the ground that charge was groundless. 16. Now there is a clear difference between section 245 and section 240 clause 1 in clause 245 of the CRBC. Under section 245(1), the magistrate has the advantage of evidence laid by the prosecution before him, and section 244, under section 244. And he has to consider whether if the evidence remains unrefuted, the conviction of the accused be warranted. If there is no discernible incriminating materials in the evidence, then the magistrate proceed to discharge the accused under section 245 clause 1 of CRBC. 17. The situation under section 245 clause 2 CRBC is however different. There, under subsection clause 2, the magistrate has power to discharging the accused at any previous stage of the case, that is, even before such evidence is laid. However, for discharging an accused under section 245 CRBC, the magistrate has to come to the finding that the charge is groundless. There is no question of any consideration of evidence at that stage because there is none. The magistrate can take this decision before accused appears or is brought before the court or evidence is laid under section 244 CRBC. The words evidence in section 240, that is there 11, Lordship.
So the magistrate seems to have taken recourse to this 245(2), that is before leading the evidence. If-
Yes,
if
but then
the
in the
court finds
ambient order,
that it is groundless.
yes, but the ambient order, time again I'm bracing this one.
Mm.
Lordship, the magistrate have stated that the evidence is taken under section 244. Page 44, kindly come to page 44.
That's
Having,
para.
having considered submission of the counsel along with the evidence of prosecution under section 244, no evidence at all, no prosecution evidence. We did not submit our list of witnesses also, Lordship. So how comes the prosecution evidence? So that is the discussion about section 244 and 245 in this judgment of the Honorable Apex Court, Lordship. Other things same. And another one, 2039 ECC. 209. In this case also, the Honorable Apex Court referred a judgment which I just read out, Lordship. On the same line, section 244 and 255.
Para.
But it's a short judgment, 3 page.
2013 9 ACC
2039 EC
209.
209. Borough 4, 6, 7, 8, 9, 10. 12, 13, 17, 18, 19, 20, and 24. May I read, Lordship?
Yes.
Paragraph 4. Page 213. The appellant case is that written submission filed by them before the magistrate raised a specific contention that no charge could be framed against him as the complainant had not laid any evidence in terms of section 244 of the court, and that the deposition recorded before the magistrate under section 202 CRBC and could not be considered as evidence for the purpose of framing the charge. The magistrate, however, brushed aside the contention and framed charge against the so-and-so under section so-and-so. Bara 6. Undeterred by the revisional order, the responding committee filed a special criminal petition number so-and-so before the High Court of so-and-so Allahabad, which application has been allowed by the High Court in terms of the order imbued before us. The High Court observed, in the facts and circumstances, in the facts of the case, it is not that the witnesses of the complainant have not been examined. Therefore, the evidence has been recorded. Therefore, at that stage, the opportunity was available with the accused as provided under law to cross-examine the witnesses. However, it is not availed or by exercising the rights of cross-examination. It cannot be said that the procedure as required is not followed. Therefore, the observation made by the learned citizen judge relying on his judgment are misconceived. It is difficult to appreciate the logic underlining the above observation. It appears that the High Court considered the position of this complainant and his witnesses recorded before the appearance of the accused under section 20BC to be evidence. Here in my case, the statement under section 200 has been taken as evidence under section 244. For the purpose of framing of charge against the appellant. Not only that the High Court by some involved process of reasoning held that the accused person had an opportunity to cross-examine the witnesses when the said deposition were recorded. The High Court was, in our opinion, in error on both the counts. We see so for reasons that are not part of the 7th. Chapter 15 of the Code of Criminal Procedure 1973 deals with a complaint made to the magistrate. Section 200, which appears in the said chapter inter alia, provides that the magistrate taking cognizance of the offense on a complaint shall examine upon oath the complainant and the witness present, if any, and the substance of such examination shall be reduced to writing and signed by the complainant and witnesses, as also the magistrate. An exception to that general rule is, however, made in terms of review to section 200, in case where the complaint is made by a public servant acting or purporting to act in discharge of his official duties, or where a court has made a complaint or the magistrate makes over the case for inquiry or trial by another magistrate under section 192 says so. I'm coming to paragraph 10, Lordship. Paragraph 8 and 9 is not relevant, Lordship. In contradistinction, chapter 19 of the code regulates trial of warrant case by the magistrate, while part A of that chapter deals with the case instituted on police report. Part B deals with the case instituted otherwise done and police report. Section 244 that appears in part B of the chapter 19 requires the magistrate to proceed to hear the prosecution, and once the accused and take all such evidence as may be produced in support of the prosecution. Once the accused appears or is brought before him, section 245 empowers the magistrate to discharge the accused upon taking all the evidence referred to in section 244. If he considered that no case against the accused has been made out which, if unreviewed, would warrant his conviction. Subsection 2 of section 245 empowers the magistrate to discharge an accused even at any previous stage, if for reason to be recorded by such magistrate, the charge are considered to be groundless. In cases where the accused is not discharged, the magistrate is required to follow the procedure under section that is not relevant, Lordship. Next, paragraph 12, Lordship. Section 244 to section 246 leave no manner of doubt that once the accused appears or is brought before the magistrate, the prosecution has to be heard, and all such evidence as is brought in support of his case recorded. The power to discharge is also under section 245, exercisable only upon taking all the evidence that is referred to in section 244. So also the power to frame charges in terms of section 246 has to be exercised on the basis of the evidence recorded under section 244. The expression when such evidence has been taken appearing in section 246 is significant and refer to the evidence that the prosecution is required to produce in terms of section 241 clause 1 of the code. There is nothing either in the provisions of section 244, 245, and 246, or any other provisions of the code for that matter, to even remotely suggest that evidence which the magistrate may be recorded at the stage of taking of the cognizance and issuing a process against the accused under chapter 15, determined to evidence that can be used by the magistrate for purpose of framing the charge just against the accused person under section 246 thereof, without the same being produced under section 244 of the code. The scheme of the two chapters is totally different. Well, chapter 5 deals with the filing of complaints, examination of the complainants and the witnesses, and taking of cognizance on the basis thereof, with or without investigation and inquiry. Chapter 19 Part B deals with trial of warrant cases treated on otherwise than the police report. The trial of an accused under chapter 19, and the evidence relevant to the same has no nexus, proximate or otherwise, with evidence used at the initial stage where magistrate records the deposition and examines the evidence for the purpose of deciding whether a case for proceeding further has been made out. All that may be said is that the evidence that was adduced before the magistrate at the stage of taking cognizance and summoning of the accused may often be the same as is adduced before the court once the accused appears pursuant to the summons. There is, however, a qualitative difference between the approach that the court adopts the evidence adduced at the stage of taking cognizance and summoning the accused, and that recorded at the trial. The difference lies in the fact that while the former is a process that is conducted in absence of the accused, the latter is undertaken in his presence with the opportunity him to cross-examine the witnesses produced before the prosecution. Paragraph 13 is the submission only, Lordship. Paragraph 17. Suffice it to say that evidence referred to in section 244, 245, and 246 must, on the plain reading of the said provisions and the provisions of the Evidence Act, be admissible only if the same is produced, and in case of documents brought in accordance with the procedure established under the Evidence Act, which includes the right of the parties against whom this evidence is produced to cross-examine the witness concerned. 18. Secondly, because of the evidence under order so and so has to be recorded in presence of the accused, and if a right of cross-examination was not available to him, he would be no more than an idle spectator in the entire process. The whole object underlining recording of evidence under section 244 after the accused is appeared is to be ensured that not only does the accused have the opportunity to hear the evidence accused him, but also to defend himself by cross-examining the witness with a view to show that the witness is either unreliable or the statement made by him doesn't have any evidentiary value or that it doesn't incriminate him. Section 245 of this code, as noticed earlier, empowers the magistrate to discharge the accused if, upon taking all the evidence referred to in section 244, he considered that no case against the accused has been made out which may warrant his conviction. Whether or not a case is made out against him can be decided only when the accused is allowed to cross-examine the witnesses. For other ways, he may not be in position to demonstrate that no case is made out against him and thereby claim a discharge under section 245 of the code. It is elementary that the ultimate quest in any judicial determination is to arrive at the truth, which is not possible unless the possession of witness cause through the fire of cross-examination. In criminal case, using a statement of witness at the trial without affording to the accused opportunity to cross-examine is tantamount to condemning him unheard. Life and liberty of the individual recognized as the most valuable rights cannot be jeopardized, left alone taken away without conceding to the accused the right to question those deposing against him from the witness box. 19. Thirdly, because of the right of cross-examination granted to the accused under section 244 to 246, even before framing of charges, doesn't in the list cause any prejudice to the complainant or the result and failure of justice. Well, denial of such a right is likely and indeed bound to prejudice the accused in his defense. The fact that after the court has found a case justifying frame of charges against the accused has a right to cross-examine the prosecuting witness under section 246. Under section 246 doesn't necessarily mean that such a right cannot be considered to the accused before the charge are framed or that the parliament intended to take away any such right at the pre-charge stage. Bara 20, we are subordinate in view taken by us by the decision of this court in Achui Kumar case. That was a case where Driel had framed charges against the accused without prosecution having any evidence whatsoever in terms of section 244. This court held that procedure adopted by the trial court was not correct because the language of section 246 clause 1 CRPC itself sufficient indicates that charge have to be framed against the accused on the basis of some evidence offered by the complainant at the stage of section 244. Court observe. This not I'm not reading that observation, Lordship. Last paragraph 21. This court further clarified that expression or any previous stage of case appearing in section 246 did not imply that the magistrate can frame charge against an accused even before any evidence was laid under section 244. This court approved the decision of the High Court of the Bombay and Suinsu, where the High Court has explained the purport of the expression at any previous stage of the case. The said expression declared this court only meant that the magistrate could frame a charge against the accused even before all the evidence which the prosecution proposed to adduce under section 244 clause 1 was recorded and nothing more.
Yes, okay. So you're saying that the 202 statements were taken as
Evidence under
244.
244. However, under section 244, it is clearly mentioned that the prosecution evidence and witnesses therefore, the learned court below, while deciding the criminal CR 12 of 24, have not followed the mandatory provision of section 244 CRPC and simply dismiss my CR under section 245 and discharge the accused. Therefore, Lordship, this impugned order passed by the learned court below is liable to be citizen quash and may be remanded back to the court below to try the case in accordance with the procedure, Lordship. Against this judgment, Lordship, I filed in the bill before the district judge Timabo. That was also dismissed by the subsequent order, upholding the illegal order passed by the CGM, Lordship. So I'm challenging both the orders.
Where is that? District and Session Judge. order?
Page 46. Same finding, Lordship. Oh, Lordship, I'm sorry. Page 58.
An extra H. Page,
58, annexure I. Same finding, no interference. The sitting judge upheld the
No, but-
legal order passed by the
Mm.
CGM.
no, but what's the present argument put before the learned session judge?
Same lordship, same argument was placed before the district sitting judge. There is no finding with regard to provision of law under section 244 and 245. Only the facts has been discussed in both the judgment, which is not at all relevant to come to conclusion with regard to allegation of forgery, lordship.
What is this criminal petition to?
Criminal petition to lordship, this criminal petition to during the pendency of this lordship, before I refer to the moving judgment, during the pendency of CR 12 of 2022, that is but pertaining to this earlier case, criminal petition. CR 12 of 2022.
Mm.
Where I've questioned the legality of the affidavit dated 15/6/2015
Mm, mm,
on the allegation of forgery, lordship.
yes.
My criminal complaint 26/2017,
Mm.
which I filed under allegation of cheating
Mm.
and breach of trust, has been dismissed on the ground that by affidavit dated 15/6/2015, the petitioner have already consented for giving up the shares. When the legality of affidavit dated 15/6/2015 is prejudiced before the court, another court, how the chief judicial magistrate come to a conclusion that the issue has been resolved by affidavit dated 15/6/2015. In Bureau is speech 70, lordship.
Page,
Page 70. Seven zero, annexure A.
yes. Mm,
May I read, lordship?
yes.
Page 71. The case of the complainant is a nutshell is that the complainant and the accused persons were business partners engaged in the business of human and animal drugs, medicine, wholesale under the name and style of modern drugs distributor having its head office in so and so, so and so. The Bauer having 1/3 each shares of the business and to this effect, data partnership data 77/2004 has been executed between the complainant and the accused person. And the accused person in contribution of the terms and condition of the date of the partnership dated 77/2004. Without notice to the complainant, part with the shares of the partners business and gifted the same to one city hit to Ahomey. Hence, the instant criminal complaint has been complaint case for criminal breach of trust, cheating with the knowledge to cause wrongful loss, cheating and criminal conspiracy. In this regard, the accused person being residents of Assam, which is outside the jurisdiction of the honorable court, issue of process have been postponed in terms of section 202 CRPC. So, has been directed to conduct inquiry and file the inquiry report to enable this honorable court to ascertain whether there exists sufficient cause to proceed with the criminal complaint case or to dismiss the case. Accordingly, inquiry report has been filed by UB side so and so, so and so, reason and decision. Lordship, I'm not on this report because my criminal petition, this petition, criminal CR 26 of 17 was dismissed on this ground. Lordship, may kindly come to page 73. Last paragraph, taking. It starts from taking.
Yes.
Taking into consideration the inquiry report, the statement of the complainant, the other materials evidence placed on record, and the section of law under which the instant criminal complaint petition is filed against the accused person, it is evident that the allegation level against the accused persons are not made out in as much as the affidavit dated 15/6/2015 is clear indication of the fact that the complainant had also considered to the handing over of the shares and then the rest of the business to series so. At the time of passing this impugned order, Lordship, the legality of affidavit dated 15/6/2015 was subjected before another court,
But this is
which is
already-
subject matter in the other petition, under criminal petition. Therefore, when the legality of this affidavit dated 15/6/2015 is subject before another court, why does CGM Dimapur have passed this judgment based on that affidavit?
So this was before CGM Dimapur and the case of forgery was before JMFC.
Yes.
This judgment is dated
This judgment is dated
11/12/23.
11/12/23.
11/12/23.
And the forgery
And
case
the
judgment is
forgery case-
31/5/24.
31.
5/24. At the time of hearing this CR 26 of 2017, the counsel for the complainant apprised the court below about the pendency of that case, where the legality of affidavit dated 15/6/2015 is sub judice. However, without considering the submission and the material placed on record with regard to pendency of the CR 12 of 2022, my case was CR 26 of 17 was dismissed on the ground that I've considered to give the shares by affidavit dated 15/6/2015. That is the reasoning given in this impugned judgment, Lordship. Therefore, I made a submission that any order passed in this criminal petition 57 of 2024 will have a bearing in this criminal petition 2 of 2024, Lordship. On that context, Lordship, I made that submission. Therefore, Lordship, this impugned order dated 11/12/22 passed in CR 26 of 2020, 26 of 17 is also really illegal and liable to be citizen of five. And direction may be issued to the CGM to proceed with the case after culmination of this CR 26, CR 12 of 2022. Now the entire issue, Lordship, entire issue, discrepancies is based on
CR 12 of 22, no?
yeah, yes, Lordship.
That one is before the JC. And CGM case is
26 of 17.
26. Yes.
So my humble submission is the Lordship. The immune judgment was in CR 26 of 2017, maybe citizen first, and direction may be issued to the CGM to proceed with the case after culmination of this forgery case. Where I made an allegation of forging my signature in affidavit dated 15/6/2015. Much obliged.
Yes.
Thanks, Lordship.
Yes.
Lordship, since the two matters, criminal petition 2 and criminal petition 7 are taken together,
Yes.
Lordship, I may be allowed to rely on the affidavit filed in criminal petition 2 of 24. That's my affidavit, Lordship. Lordship, first of all, since my learned friend.
One
has-
and two, respondent 1 and 2.
Respond 1 and 2, Lord. I'm for the respond 1 and 2, Lord. First of all, Lordship, in respect of the criminal petition 7 of 2024. Criminal petition 57 of 2024, Lordship. Lordship, I have not filed my affidavit in criminal petition 57.
Mm.
Lordship, but I filed my affidavit in the
In 2, it's there.
2,
Yes.
Lordship.
Separate petitions you have filed, separate reply.
Separate reply since respond 1 and respond 1 and 2, Lordship.
Okay.
But I've not filed in the criminal petition 57. I may be allowed to
Yes.
take.
You're relying on written of even opposition of R1
Yes, for R1 and 2
Mm.
in
in 2
criminal
of
petition 2 and
24.
3. Lordship, Lordship, first of all, Lordship, in criminal petition, since my learned friend has argued on criminal petition 7 to 2024, Lordship, Lordship, I may be allowed to take Lordship on at page number 1, Lordship, page 1 of the criminal petition. Page 1 of the criminal petition, Lordship, cited. Lordship,
Page
since
1.
the issue.
The course title.
Yes, the space, Lord.
Mm.
Since the issue
Mm.
before the JMFC and the Sessions Court were taken under the sections, the penal sections are taken under CRPC and IPC. And the petitioner here has filed under section,
Under BNSS.
under BNSS. So will that be applicable? That's
Yes,
one,
after the
since, Lordship,
No.
as per the notification, Lordship.
Actually, as per the notification, which the proceedings which were being taken up under IPC will continue under IPC and CRPC. Yes, and then the new ones.
But then I filed this criminal petition
Mm.
under the new BNSS.
No, I mean, the proceedings before the trial court
Yes, yes, that can be,
were under
proceed.
IPC and CRPC, no?
that can be, that can be proceeded in
Mm.
terms of the earlier.
Yeah, it's okay, that, anyway,
Yes,
I'll take note of it.
Lordship, so whether the petition is maintainable, Lordship. And Lordships, first of all, Lordship, I may be allowed to take Lordship to, without going to
Yes,
the facts, Lordship, since your Lordship has, my
yes.
learned friend is explain the facts, Lordship, may be allowed to take Lordship to page 37, annexure E.
Yes. 37 is annexure F.
My apologies. Annexure F, that is the inquiry report, Lordship.
Mm.
In the inquiry report, that is after the petitioner has
Mm.
filed the CR case 12 of 22
Mm.
under section 468, 471, 14T506, and 34 of IPC. Your lordship may come to page 39. The inquiry report.
Mm.
Lordship, that's second paragraph, lordship, I may be allowed to read, lordship. Further, regarding the alleged forgery of document enclosed as Annexure C as per witnesses, it has been confirmed that all the parties, including the signatories in the agreement, were present and was duly registered and notarized. On the other hand, during interrogation of the alleged accused persons, they stated that even before the said alleged forged document was made, the issue pertaining to the partnership between Sri Hetoi Aumi and Srimati Mampipol and the gifting of their shares to Sri Hetoi Aumi had already been resolved during the meeting with NMDA, National Nagaland Medical Dealers Association, executing body on 2nd June 2015. And whereas the alleged forged document was made on 15th of June 2015, therefore, they had no reason to forge the said alleged document. There's the inquiry report. Your Honor, lordship, I may be allowed to rely on my affidavit. In my affidavit, lordship, page 19. My affidavit in that is in criminal petition 2 of 24.
Of R1.
R1.
Page 19.
That'll be page 20 in R1.
List of witnesses.
Mm,
No, that is 17.
Decision of understanding.
Oh, okay. Resolution.
Resolution of
Resolution
understanding.
Understanding. Page,
That is dated 2/6/2015.
next June, R3. Dated
2/6/2015.
2015.
Resolution of understanding.
Hmm.
This is in respect of the affidavit,
Okay.
which the petitioner is alleging that are forged.
Mhm.
In connection to the dispute between the partners of MS Modern Drug Distributors, JS Road, Dimapur, which was brought to the office of the NMDA by all the three partners, the following resolution have been agreed upon by all of them amicably in presence of NMDA executive body. That all the issues pertaining to previous transactions of personal expenditures / investment shall be treated as null and void in absence of legal receipts from any of the partners. 2, that the two partners, 1, Srimati Jaita Das and 2, Srimati Jumnu Devnath, they are the respondent 1 and 2, has gifted their share to Mr. Sri Hetoi Aumi, son of so-and-so Dimapur. That henceforth 2/3 partnership will go to Mr. So-and-so and 1/3 will belong to Srimati Mampipol, that is the petitioner lordship. That with the present partners will decide the new system of business relating to MS Modern Drug Distributors amicably without any outside interference or MDA interference. And lordship, the signatories are at the right side. 1 is the attorney holder of the petitioner. Put a signature has been signed. And the other partner and 4 and 5 are the husbands of the respondent 1 and 2. So when in the year 2015, on 2nd June 2015, and they have resolved, lordship, and the affidavit has been executed on 15. And when the inquiry was carried out by the inquiry officer, they have, all the witnesses have stated that there was no forgery. The question of filing the present criminal petition against the accused, Lordship, is not maintainable. That's my.
On 2nd June 2015, when the resolution was adopted, your attorney holder has also signed. So
Yes.
what do you say about this?
Lordship. Me kindly, I'm reading paragraph 2, the same, resolution, Lordship. Since it is on facts, Lordship, I've not submitted anything on this issue.
No, but that is their main
Yes,
ground.
yes. Resolution of understanding.
Yes,
Just now my narration is referred to.
yes.
Paragraph 2.
Mm.
That the two partners, Srimati Swinso, has gifted their shares to Swinso. This is on 2/6/2015.
Mm.
And now dear case is based on the affidavit dated 15/6/2015, whereby I have agreed, the petitioner have agreed to give the shares. They have kept it, their shares to Hitui. Has Lordship got it? The date.
This is 2/6.
On 2/6, they've already gifted.
And that affidavit was dated
15/6.
15/6.
25.
Is it not contradictory, Lordship? On 2/6/2015, the respondent have already gifted their shares illegally. And now they are coming with an affidavit dated 15/6/2015. That based on this, we have gifted the shares, which is subsequent to 2/6/2015. Something fishy is there, Lordship. That's why, Lordship, since this all are facts, I didn't make any submission on this issue. But then the record is very clear, Lordship. On 2/6/15, they have stated that they have gifted their shares already. On 2/6. And now they are relying on an forged document studies 15/6/2015. That on the strength of this affidavit, we gifted our shares. Is it not contradictory, Lordship?
But why did you sign this resolution then? Your attorney holder? Because here it says that
So, Lordship,
they have gifted their shares
I was compelled, Lordship.
and
I was
you-
compelled.
Lordship, the
Due to local pressure also, Lordship, I was compelled to sign.
inquiry report. The inquiry report, Lordship, I may be allowed to refer again, Lordship. Further, regarding the alleged forgery of document enclosed as Annexure C, as per witnesses, it has been confirmed that all the parties,
Where are you
including-
reading? Page
page 39,
39.
I'm reading again the same paragraph.
Okay, continue.
Further, regarding the alleged forgery of the document enclosed as Annexure C, as per witnesses, it has been confirmed that all the parties, including the signatories in the agreement, were present and was duly registered and notarized. On the other hand, during the interrogation of the alleged accused persons, they said that even before the said alleged forged document was made, the issue pertaining to the partnership between so and so and gifting the shares to Mr. So and so has already been resolved during the meeting so and so. And whereas the alleged forged document was made on so and so, therefore they have no reasons to forge the said alleged document. And your Lordship may come to page 40. The next page, that is number 6, same paragraph. That on June 15, an affidavit was framed by Srimati Mampipol. Srimati Mampipol, there's a petitioner, wherein it stated that after having due consultation with her co-partners, Srimati Jarita Das and Srimati Jamun Devnath both have been handed over their shares to Mr. Etoy Aomi, copy enclosed in Annex C. Further, as a witnesses, the said document was personally produced by Srimati People to be registered and notarized. That is the report of the inquiry officer. Yeah. So basing on the inquiry report, the court, the MSP court as well as the sessions court the learned session courts have come to a conclusion that and pass the impugn orders that are before this honorable court, challenged under before this honorable court.
So do you say that section 244 CIPC has been complied with?
No, your in respect of the section, your 244, your worship may come to page 26. First of all, page 21. Page 21 is the CR case number 12 of 2022. Page 21.
Page 21 where?
In criminal petition 57.
57.
724.
Page?
Page 21, annexure B. That is a criminal petition.
Yes.
Relevant portion is at page 26.
Yes.
List of witnesses. The complainant herself through her attorney holder, Sopan Datta, so and so, that is the second witness. And their evidence has been produced at page 56 and 57. Form for recording deposition. Fifty-seven is the witness. 56 is the complainant, the attorney holder, the petitioner. So their evidence has been taken on oath. As such, the provisions of section 244 such this section, the provision of section 244 CRPC has been complied with, and the learned MFC court passed an order under 245 by discharging the accused.
So in 57, that is your submission.
Yes.
Then what about 2?
In two. You may come to page 22 of the criminal petition 2. Page 22. That is the deed of partnership between the petitioner and the respondent. Executed in the year 2007, 4. 2000, in the year 2004. the relevant pages of page 27. Page 27, serial number 25. Maybe we'll have to read. No. That disputes with any third party may be referred to arbitration by any partner, and such partner shall have all powers to take necessary steps in the best interest of the firm till such arbitration proceedings come to an end. The award is made a rule of the court. Since Lordship, the petitioner is dragging the respondents to the criminal court, even though the nature is civil in nature, since there's a contract, since the date of partnership between the petitioner as well as the respondents. And next page also, Your Lordship, page 28. Even here also there's been repeated regarding the arbitration. That is serial number 27.
You have made amendments in your pleading about this. Regarding the arbitration clause. The court cannot go beyond your pleadings. No?
Yes, Lordship. Your Lordship, I've made the pleading that the matter is purely civil in nature.
That is
That's
their
a
paragraph.
civil dispute.
That civil dispute arising from a partnership agreement.
Yes.
But you have not stated about the arbitration clause.
Yes, yeah. Specifically, I've not mentioned.
Yes. So you're saying since
Lordship,
arbitration clause is there, arbitration should have been resorted to and not a criminal proceeding.
Yes, and since there's a partnership deed between the parties, that is the petitioner and the respondents, the two respondents, this dispute is civil in nature. And instead of resorting to a criminal proceeding, the party should have come to a form of arbitration or either a civil dispute. Civil forum.
What about the allegation of forgery?
With respect to the forgery, Lordship, since after the petitioners have filed a criminal complaint and its honorable court, when the process of section 200 was not complied with, 202 was not complied with, directed to comply the provisions of 202 CRPC, and on compliance of the section of 202, the learned court below has directed the inquiry officer to take up the inquiry regarding the subject matter, and the inquiry report is before this honorable court, where I've specifically stated that as per the inquiry officer, there was no forgery, but in fact, the petitioner herself has given the document for notary. The the document in question. And as such, there is no infirmity or there is no illegality of the learned court below passing the impugn order dated 11/12/2023.
Just one clarification, Lordship, with regard to arbitration.
Mm.
Just now, my friends read out the partnership date, paragraph 27.
But they have not refuted in their readings.
Even then, Lordship,
Mm.
cheating and criminal breach of trust doesn't amount to dispute.
Mm.
Clause 17 says if there is any dispute. So within cheating and allegation of criminal breach of trust amounts to a dispute between the partners, no, Lordship. Clause 27 says, if any dispute arises between the parties, either as regards their partnership business or as regards interpretation of any clause.
Mm.
There's no thought about any clause, interpretation of any clause. And whether my complaint for cheating and criminal breach of trust amounts to dispute between the parties. No, Lordship. Therefore, the issue of arbitration doesn't arise here. And my case was not dismissed on the ground that arbitration clause is there. Dismissal order is on different line, Lordship.
That issue was never raised
Yes.
before the trial court
Yes.
also.
So that submission made by my learned friend is irrelevant. Oh, please.
Order received.
For hearing, item number 17.
Bill.
May please, your lordship.
Yes.
Lordship, this is a criminal appeal.
Service complete.
Service complete.
Has been appointed as Michael's.
The maker's query has been.
For R2. Yes.
This is a criminal appeal under section 374 CRPC. Challenging the judgment and order dated 11/4/2023.
Mm.
Lordship, in this particular matter, I was charged under section 354, read with section 8 of SECTO
Mm.
for sexual assault, but convicted under section 354A1(1), read with section 12 of POCSO. Initial charge.
Where is the FIS?
Copy of the FIR has not been annexed.
Okay, page 43.
45, 46.
So charge was initially under 376.
Initially in the FIR, it was under 376,
Yes,
but later on cognizance was taken under 350.
See, then cognizance taken under. Yes, later cognizance was taken under section
354,
354.
read with section 8 of POCSO.
Read with section 8 of POCSO.
Yes.
And conviction was under
Conviction under section 354A 1 subclause 1.
1 IPC, read with section 12.
And section 12 of POCSO for sexual harassment. Lordship,
Yes.
If Lordship may kindly refer to the judgment, page 38, the observation. After, after 13 witnesses were examined from the prosecution side. And after examination of the witness, out of that, 2 number of eyewitnesses, including the prosecutrix and her brother, with the PW3. So total 2 number of eyewitnesses were there. I was not found guilty under section under which I was charged. But I was convicted under section for sexual harassment and convicted. I was convicted for a jail period of 13 months approximately. Since during the period, my period of jail term, during the trial period, that was considered as my punishment period. And later on,
as a UTP, you were
during the
for
trial
how long?
period, I was in detention. And that, and when the conviction was given, during that time, that particular period of 13 months was considered as my punishment period.
So you did not serve any time after the judgment?
No, that was considered. Now, Lordship, after examining the witnesses and the DW as well as the PWs, the observation made by in the impugned judgment by the Honorable POCSO judge, it was concluded in that particular judgment that
Page
38. 38. No, if Lordship may allow, I will kindly go through this observation.
Yes.
Now let us dwell on the other aspect of the prosecution story. It is no doubt that the prosecution has failed to prove the case on the charges of sexual assault or use of criminal force upon the victim. However, it is an admitted fact that the alleged accused has conducted medical checkup upon the victim. That was a part of the observation. As such, the issue as is discussed in detail is made out that the alleged accused is a science teacher, and as such he is not a medical practitioner, and the fact that he is a teacher and not a medical practitioner, he is not legally bound to conduct any medical checkup, nor does he possess any certificate of practice as a medical practitioner. Further, it is also established that being an unqualified and non-professional medical expert at the outset, he was not authorized by law to conduct any medical examination upon the victim or for that matter to any person. Now, but it is made out that the alleged accused has physical contact with the victim, to which it is evident from the testimony of PW3 and is not denied by the alleged accused. Therefore, though the prosecution has failed to prove its case against the alleged accused of sexual assault or criminal force, it is made out that the alleged accused has, while conducting checkup, had physical contact and advanced near the victim. As such, committing an act of sexual harassment under 354 so and so, as well as under section 12 of POCSO, as the alleged accused had not found, was not bound by to medically examine the victim, nor was authorized by any authority to do so. Now, coming to this, Your Lordship, if we go through the observation again made by the learned judge in the imputed order, she has contradicted in her conclusion. She has contradicted the conclusion that she had drawn from after going through the submission of the witnesses. It was in page number and para number 15.7, page number 30. Page number 30. It is important to note that the allegation against the alleged accused is of assault and using of criminal force. However, in spite of the fact that the alleged accused was molesting the victim did not raise any hue or cry, even though her cousin brother, PW3, was in the adjacent side, which creates doubt as to the testimony of the victim regarding the criminal force being used by the alleged accused. There is also no material or circumstantial evidence which can be said that the alleged accused has caused any injury, fear, or annoyance to the victim. The observation that I had just now gone through contradicts the observation that was made in this particular paragraph. Here, in the presence of PW3, the Honorable Judge, she had Honorable learned Judge, she had accepted the fact that the testimony of the victim contradicts with the testimony of PW3. There is no material or circumstantial evidence which can be said that the alleged accused has caused an injury or fear or annoyance to the victim. Again, on para 1510, Lordship may kindly go to page 31. 1510, here it is stated that given the fact and circumstances, there are no record circumstantial evidence or material evidence to show that the alleged accused has made any gesture or preparation. Furthermore,
Please continue at 2. Please continue at 2.
Okay.
Three one zero PL M P 321051. 310 PL M
You're gonna stop streaming video. End podcast mana kan? Di sana dulu. Di sana dulu. Iya. 10 tidak. Thank you very much.
Yes. Para 1510.
Wait, please, your lordship. Lordship, the para number 1510 is one of the observations that has been made by the learned trial court. Here, as per 1510, it is the basic findings from this particular para is that alleged accused, the victim was made to lie on the bed and was medically checked by the alleged accused in front of PW3. As such, it is hard to believe that any prudent man would do such act in front of a relative or family member, which is highly improbable. That means the learned trial court has contradicted, or the situation was such that the only eyewitness, that is PW3, in front of him, any occurrence or incidents of such type is not probable or not likely to happen, because the PW3 is the brother of the victim, cousin brother. Now, your lordship, going back to the whole scenario under which this particular incident or this alleged incident is said to have been occurred. The place of occurrence was my house. The victim and her brother, that is PW3, they went to my house to take admission. The victim was a student, I was the teacher of the school. The victim accompanied her brother to take admission in the school, and for that purpose, she came to my house along with her brother in the evening hours. And as per the statement of PW3, it was their decision, conscious decision, to come to my house in the evening hour, because he was working in the field during the day. And then he went to my house in the evening because he could make time for his sister, that is the victim, to accompany her to take admission. Moreover, as per PW3, the victim was not feeling well during that period. She was not well. She was suffering from cough and cold. That was also the statement of the brother of the victim. And it reflects in the observation of the Honorable Trial Court. Now,
has the court said anything about the deposition of PW3 in the judgment?
PW3, it has been mentioned.
Let's see.
1526. 15. Where are 1526? Oh, it's in the reason. 26. It is pertinent to mention here that the victim during her recording of statement under 164 before the Nagaland deposed that the alleged accused had messaged.
This is victim
Acha,
statement.
victim statement. 15:7. 15:28. 15:28. Hence, this court is of the view that solitary evidence of the further submit no injury was found.
PW3 who did not notice any unusual activity.
15:28.
15:28.
And the statement of PW3 who did not notice any unusual activity between the alleged accused and the victim creates enormous doubt on the testimony of the prosecutrix. As such, the alleged accused is entitled to benefit of doubt. So aspirations were casted by the learned trial court on the statement of the prosecutrix. Moreover, as per the statement of the victim, I touched her body with bare hands. But as per the PW3, her brother, I was using stethoscope. So there also contradiction in their statement. One is that is the victim is trying to say that she has already deposed that I have used my bare hands and I put some ointments on her and I touched her private parts. Whereas the PW3 who was sitting in that room at the place of occurrence nearby, he mentioned that I was using stethoscope. So there is a contradiction. Now, based on this contradiction, the learned trial court has rightly pointed out that this particular incident is not likely to happen and there is contradiction between both the person, statement of both the person. That so far, analyzing the statement of both the witnesses, the learned trial court has come up to a cogent and very reasonable conclusion that there was no intention on my part to commit any crime of such manner. And at the same time, the learned trial court has also said that the facts, because of the statement, different statements given by both the person, the facts also do not point out that such a thing could have happened. There were enough, the statements point to enough, give rise to enough doubts so as to convict a person under the charge sections. Now, Your Honor, now Your Lordship, if we go by the point 15.7, nothing to show that the action, if any, of the accused caused fear or annoyance to the victim. That has already been discussed. Second, in point number 15.10, nothing to show that there was any form of gesture by the accused and therefore improbable, not prudent, to believe of any indecent gesture by the accused in the presence of PW3, the brother of the victim. Again, as per para 28, I have already stated before Your Lordship that PW3 did not notice any unusual activity between the victim and the accused. Now, there is contradiction in testimonies of PW2 and PW3, which were both present in the room. Therefore, conviction on the use of stethoscope per se, even if done without any proof or wrongdoing, bad intention will stand on suspicion alone. So this is what my submission would be. That despite the learned trial court coming to this finding, that there was no intention, there was the condition or the circumstances was not favorable for happening of any case of sexual harassment or assault. But at the end, the learned trial court convicted me of sexual harassment despite not accepting the fact that these two conditions necessary for such an act has not been fulfilled. And learned trial court at the same time in para 1530 has also accepted that there is so much weight of contradiction that doubt is obvious in the face of truthfulness. This is the observation made by the learned trial court. 1530. Page number 37, 38.
Yes, yes.
38.
Search the evidence on record, so much so weight of contradiction cropped up this on the footage of aforesaid observation has inflicted the persecution from the fatal shadow of doubt.
The footage of the
14.1 and 14.2 are disposed in negative. So 14.1 and 14.2.
are disposed in negative.
Whether the accused, namely Tristan and such, assaulted or used criminal force.
Sorry for the indulgence, Lordship.
Yes.
Lordship, since the appellant, they are relying on the deposition, Lordship, and they have not annexed, Lordship. So, Lordship, as officer of the court, it will be difficult for us.
Unable
accept,
to.
Lordship.
But
Of
Lordship,
course,
and,
LCR is there, but then.
Yes, Lordship, and then they have to come by way of paper publication. And
Yes.
moreover, Lordship, since
See, normally what they do is, when you're relying on the depositions of PW3 or the prosecutrix, whatever, that portion has to be reflected in your petition.
But Lordship,
Extract.
Lordship.
I agree, Lordship. But Lordship, at the same time, we are challenging the observation and the decision of the trial court. The observation has been taken after going through all the statements. This has been discussed threadbare by the learned trial court, and after that, the learned trial court has come to this.
What they are trying to portray is that the trial court has contradicted itself by saying something but arriving at something else.
Yes, our main challenge is that, because whether using a stethoscope, using the final observation is that, the final observation of the learned trial court is that.
See, the points for consideration also, usually the criminal court will always frame points for consideration, and on that basis, the judgment will be pronounced. So the 2 points are 14.1 and 14.2.
Yes.
Para 14.
Lordship,
So here 14.1, court has said, whether alleged accused such and such has assaulted or used criminal force upon the victim with intent to outrage her modesty under 354 IPC. And 14.2 is whether prosecution has been able to prove the case against alleged such and such under section 8. So to this 14.1 and 14.2, court says at 1530 that the point number 14.1 and 14.2 are disposed in negative
Lordship.
against the state.
Lordship, however, now the issue remains
Hmm.
whether they can approach the Honorable High Court by way of filing an appeal. Lordship, here the order dated, the judgment passed by the special judge Mon.
Hmm.
Lordship, may kindly come to page 41, Lordship.
Page 41.
Page 41.
Yes.
Page 41. 18.2, Lordship. Considering all aspects,
15.2.
18.2.
Okay.
Lordship has got.
Yes.
Considering all aspects, accused OM Prakash Shah is hereby sentenced to 1 year and 1 month and 3 weeks, Lordship. Here, Lordship, as far as CRPC, section 374, 374 is concerned, Lordship, 374 clause 2. Clause 2. May I read, Lordship?
Yes.
Any person convicted on trial held by a session judge or an additional session judge
It's
or on a trial held by any other court in which a sentence of imprisonment for more than 7 years. Here it stated that it's more than 7 years. However, to here they got
This is 1 year,
lordship.
1 year, 1 month.
So it has to come by way of revision lordship, not by way of the appeal lordship.
This, may I, Lordship?
Yes. This is an
Lordship, in
appeal.
fact, this point was raised by earlier during the time of admission.
Mm.
And I have stated, citing that this particular law 374, it is very much clear that this matter is appealable in the High Court. And after that only the matter has been admitted for hearing. Here, one thing my learned friend has probably missed one particular thing. 374, any person convicted on trial held by a sessions judge or an additional sessions judge or on a trial. Here, one thing is confusing, and most of the time one might get confused, that here it is very clearly written in 374(2), any person convicted on a trial held by a sessions judge or an additional sessions judge. Additional, and a POXO judge, a judge who is in charge of a POXO court, is an additional sessions judge. She is, and if we go by the order, we'll find that she is an additional, the learned
In
trial court
Nagaland-
judge was an
Nagaland,
additional.
We don't have additional session judge, so everyone is session judge.
No, lordship.
A session, yes, sessions judge or equivalent.
Equivalent.
So definitely by that particular reason, a trial held by a sessions judge or an additional sessions judge or on a trial held by any other court, in case the trial is not conducted by the sessions judge or additional sessions judge, if it is conducted by any other court lower than the sessions judge or additional sessions judge, in which a sentence of imprisonment is more than 7 years. When a sentence passed by a judge who is lower than the sessions judge or an additional sessions judge, then the sentence has to be more than 7 years. Then only it is appealable in the High Court. Otherwise, any order passed by the sessions judge
Yes,
or
yes.
additional sessions judge.
Yeah, we have to interpret it that way. Session judge, it
Oh.
can be an appeal against order of a session judge or additional, but if it's some other court, then it has to be a sentence of more than 7 years.
This is
Mm.
a bit, even
Yes, yes.
before filing this particular, this is just I am sharing with Lordship. Before filing this appeal, even I was also confused.
Mm.
I got confused, and after that,
Mm.
getting clarification
On a
only I
trial
have filed
held
it.
by any other
And-
court in which a sentence of imprisonment for more than 7 years has been passed. Yes, yes. Because see, the logic is sessions or additional can even give life imprisonment, nah?
No.
Whereas the other courts cannot. So for them, for other courts, it has to be more than 7 years. That is the point. Anyway, yes.
And that is, the learned honorable court has already admitted the matter for
Yes.
final hearing.
Yes.
Lordship, since in the paragraph, page 8, paragraph 8 and 9, Lordship,
Hmm.
they have raised the same grounds, Lordship. Grounds under section 313 CRPC, Lordship.
Hmm. No, if you want time to go through the LCR,
Lordship.
I can give you time.
Lordship.
Yeah. No, not an issue. Because the LCR is here.
Or else.
Even I have a copy. I can give you a copy of that.
Ordinarily, otherwise, we prepare paper book.
Paper book,
Paper
normally we prepare
Normally
paper book.
paper book.
Mm. Because all the parties has to see the
Lordship,
LCR.
Lordship, definitely.
Lordship, actually, I had taken the copy from the trial court.
Mm.
So I cannot verify this is the set with me. I cannot verify that
You
all
never
the
know, some
all the pages are
yes,
there or not.
yeah.
Yes, but
I cannot guarantee that.
Lordship,
That's why-
let them prepare by way of paper.
The parties, to be fair to all the
But
parties, no?
But this is a certified copy. He can take it.
Okay, we'll give direction for preparation of paper book. That will be the best. Otherwise, they will not
That
be
would
able
be
to
our
refute,
best.
no? Mm.
But Lordship,
Upon hearing, yes, upon hearing learned counsel for the parties, it is seen that the paper book needs to be prepared in this case, as the petitioners, as the appellants are relying on certain depositions made by the PWs and also the 313 statement of the accused person. So, registry is directed to prepare the paper book on cost to be borne by the parties,
By the
by the appellant, yes, by the appellant. How much time will it take? 4 weeks. 4 weeks is not enough. 6 weeks.
Normally,
Normally, how much time? will it take?
normally the direction is that the matter may be listed after.
After preparation of the, but
Correct.
that, well, again, we don't know how long that will take. 2 months.
Lordship, a date may be fixed because I come from Gauhati. So without
Okay, okay. List the matter after the preparation. Or we'll just say after preparation of the paper book. Mm. Mm.
Bless.
You have a junior counsel here in.
Yes, yes, I think
You communicate with him and when
Yes, sir.
the paper will be completed. You have to pay in case, yes, you can pay in case. Which is simpler, because if you make one company, you have to run around in the.
No, I'll pay in cash. If that is-
When the paper will be completed.
But we'll get, we'll.
Doing your case very well.